That matter's ready, Your Honor.
Who else do I have present on this matter? I have Ms. Day.
And you have Miss Rebecca Ford, the mother of the child. And my client is here, Mr. Cox.
All right, so this is on for a review of how Ms. Day is doing regarding investigation. So let's start there. Ms. Day?
Yes, Your Honor. I've been able to meet with the mother and had her do a walkthrough of the home and obtain the necessary information to move forward with my investigation, but I've not had any contact to speak of with the father. He has indicated he would meet with me after he had a chance to talk with his attorney, but I haven't had any contact outside of that. In that discussion, there was some discussion that there might be an agreement forthcoming, but I don't know the status of that.
Okay. Mr. Anagnostou?
Yes, Your Honor, and I apologize. I get sidetracked and was able to work on this weekend. And I talked with my client. I talked with Ms. Day, and I actually talked with Ms. Ford this morning. And I think we have an agreement. My client is going to agree that the daughter, Rebecca, be allowed to relocate to Colorado with the mother, that she would be given the primary residential placement of their daughter. He'd like a parenting plan that says he gets a couple of weeks in the summer and sometime over Christmas and phone contact, but he's not going to enforce that. So we would have to have a parenting plan that says visitation and contact will be as agreed between the mother and the father and the child. She is older. I think she's 16, somewhere in there. And so my client's not going to force it. But we'd do an agreed parenting plan in the family law matter, and then this matter would be dismissed and the child would go to the mother.
Okay. So Ms. Ford.
Not this matter. This matter wouldn't be dismissed. The guardianship would be dismissed.
Right. Ms. Ford, anything from you?
Well, Your Honor, after speaking with my daughter, she has made it clear to me that she doesn't want contact right now with her father. So I'm not sure on what to do or what to say.
Okay. All right. So it sounds like it's still kind of in the works. So what I would suggest is we set this over a couple of weeks, see if you can work it out. And then if it's taken care of, then we don't need to do anything further on the docket. So that's what I'm thinking. Ms. Ford.
I would agree, Your Honor. I think that makes good sense and gives the parties a chance to hammer out any details.
Okay. Ms. Ford, are you okay with that?
Yes, ma'am.
All right. Mr. Anagnostou, does that work for you?
Yes, that works for me.
Weren't you gone at some point in June, or is that later?
In the middle of June, Your Honor, from the 16th through the 29th.
Okay. So how about if we continue it to June 11? Are you okay?
Yeah, that should be fine.
Okay. All right. All right. So for everybody to know, that's just because I do the scheduling calendar too. So that's why I know that. So with that, let's go ahead and set this over to June 11, just to see where things are at, and go from there.
Very good.
Thank you, Your Honor.
4-08 Brownitz and Bob matter.
That matter's ready, Your Honor.
Who else do I have? I have Mr. Bob present. Do I have Mandy Brownitz present? I see you on here, Ms. Brownitz. Seems like she's having difficulty with the sound. Why don't you log out and log back in, Ms. Brownitz?
And do you want to come back to us, Your Honor?
Yeah, well, I'll come back to you.
Your Honor, I was just wondering if I could inquire. We filed a declaration late last week, responsive declaration of my client. I'm just wondering if Your Honor has received it.
Hold on, let me get to the full matter. So the last thing that I have is from April 8, 24. I do not have anything. Let me just double check. I thought I had.
Yeah, we sent up a bench copy for your honor, but
I don't see anything. Oh, yes, I did see it. I thought I had. So I do have that. Okay,
and I had spoke with counsel prior indicating that the declaration wouldn't be timely pursuant to local court rules, and he was okay with that.
okay. All right, any objections, Mr.
No,
Sand?
that's fine, Judge. I just asked for maybe a little bit of leeway on any SIR reply that I might need to give.
That's fine. All right, counsel, go ahead.
Yeah, thank you, Your Honor. The court's aware, I do represent the petitioner moving party to the motion before you today, namely Bobby Hodges. This is a case with extensive history. The parties have been in court since the child, Landon, now almost 16 years old, was a very young child. Parties eventually adopted and came into a joint residential plan. 2017, that changed. You're well aware of why that is. That was in the pleadings and contained therein. And we're at a point now where the parties have dragged on due to that modification in 2017, 2018, due to COVID, due to evaluations, due to criminal charges, due most recently to Ms. Wanzer's medical issues. This case has just unfortunately become a marathon. Now at a point where Landon is 15 and a half years old. He's on the verge of driving. This is a child who's now, as many high school kids do, find their independence. It's a child who has always been very closely bonded with dad. This is a child who, and I think the GAL says it quite succinctly, wants to please, wants to have both parents in his life, but is, quote, adamant about spending more time with his father. We go back to the 2017, which kind of upset the apple cart a little bit. The allegations of both parties going both ways. These are parties that have been traditionally in a long-standing conflict with one another. This has unfortunately impacted the child to some degree. These are parties who did best when there was a joint plan that was being undertaken. So again, I think if we look at that from a historical prospect, again, that's when the parties did best. If we look at what has occurred since 2017, again, I think it's clear. I don't think it's disputed that my client has done absolutely everything that was expected of him, plus so much more. It's a fact that was recognized by Mr. Lawrence in his most recent GAL recommendation and report. And again, it's a case where my client should be commended for, excuse me, the work he has done on himself to be a better parent to this child. You look at specifically those details. My client has continued counseling with Dr. Johnson for a significant period of time. We've given you reports from prior that Dr. Johnson says he's been an ideal patient, done everything that was expected of him. Giving you information from Stacy McFadden, who again says Bobby went through the program with flying colors, again, did everything that was expected of him and then some. Giving you records from Columbia County, Oregon, showing that my client complied and did everything that was expected of him through that. Matter is now dismissed. And again, that's to his credit. He's gone through full psychological testing. He's gone through that with parental risk assessments and components. And again, all this information leads to a conclusion by every expert in front of you that he's at absolutely no risk to this child. In addition to doing what was court ordered, he took it upon himself. And again, I think this is something that people do this when it's court ordered. Rarely do we see this where it's not. My client went to Washington State University, which at the time I didn't know even offered these types of programs, underwent an intensive parenting class. In which he's learning from not only just providers at the institution, but as well as other participants about techniques to be a better parent, better person, and he's done that. So again, we provided you in the past with information relating to that. We're at a point now where we had trials scheduled for the fall. Baum unfortunately had some physical health concerns, which by stipulation, we thought it only appropriate to continue that. This is a case that's been continued in the past for trials. And at the time back in the fall, parties agreed to have a fresh look, fresh perspective on that, agreed to use the services of Mr. Lawrence, agreed to give the court some updated information. That's what we have today. I went through the winter, complying with that, going through the hoops of that, and the evaluation, or excuse me, the investigation in and of itself. Mr. Lawrence published his findings after the first of the year. We note that up based on that. And again, we're talking about a 15-and-a-half-year-old child. Well, everybody would like the opportunity to go to trial and present their evidence. Unfortunately, that's not as easy as it otherwise should be. My concern is we get pushed out to trial sometime in late 2024, if not 2025, and due to things getting back to semi-normal now, that gets continued. At this rate, the child's going to age out. This is a child who is in some kind of dire consequence right now. This is a child who you can see in Mr. Lawrence's investigation is suffering a little bit. Is having some emotional issue with this. This is a child whose voice, he wants it to be heard. This is a child who's gone out of his way to contact the GAL, unbeknownst to my client, theoretically unbeknownst to Ms. Wanzer. and said, I want to live with dad. That was only several weeks ago. So if you look at it again from that perspective, this is a young man who wants adequate time with dad. It's a young man who's struggling a little bit with mom. We've detailed for you what we believe is happening at mom's, which is mom isolates herself, whether that's due to the physical condition, and again, which is completely understandable, or to do some other activity, again, takes away from time with the child. Regardless of what the root cause of that is, my client lives literally 2 blocks away. This child has asked, can I walk to dad's house? Can I go to dad's house? And is met with firm resistance of mom. Again, I don't believe that's due in part to recognize that there might be dangers at dad's house and that might be some kind of a concern to the child. I think it's due to the conflict between the parents that has been there for the better part of 10 to 12 years. So again, if we step outside of ourselves, look at the best interest of the child has spoken. Mr. Lawrence has made very clear findings. Child deserves to have more time with dad. Parts that stand out to me most notably from Mr. Lawrence is that, again, as suggested, Landon is requesting more time with his father. Landon is a quiet boy. He loves both his parents. He does not want to hurt either. However, he is adamant that he wants to spend more time with dad. You go on to that, and again, there have been no allegations of assault nor child abuse since. Bobby successfully completed his deferred prosecution agreement, completed DV in a year-long treatment, and ultimately, Mr. Lawrence cites, I see no issue that would preclude Landon from having more time with his dad. Also recommended this joint plan, which we have proposed in our parenting plan. We're at a point now where, again, this child needs some healing. I think he needs some healing, and he needs to feel like the court and the parties, but more importantly, are recognizing his growing independence as a near 16-year-old child. This matter was originally set for May 14th. We had filed it in early April, given ample time, and we kicked that out to May 14th. Counsel is correct. We did have a conversation about getting this child in family counseling with mom. It was my understanding in early May when counsel and I first spoke that was about ready to happen. Now, after getting the declaration from Ms. Wanzer on Thursday, it looks like that has yet to happen. My client, again, wants this child to have a relationship with both parties. Doesn't want this child to be estranged from his mom. So I was willing to kick it out 2 weeks. And again, it looks like that unfortunately has not happened. We did not get an opportunity, as noted in my prior comments, to file a SIR reply, given the timing of this in the 3-day weekend. But nonetheless, my client will fully cooperate with the child and mom healing, will fully cooperate with the counseling efforts, as we believe that's a good idea. The fact that after the report was issued, child reaches out to Keith Lawrence, contacts him and says, I'm having more problems with moms and I want to be there with dad on a primary basis. Again, it's kind of telling where this child is on an emotional level. Why? We don't really know, but he's there. We can recognize that, and we can let some of this tension out a little bit if we recognize that. If we allow the child to go back to what he knew originally, which was the week on, week off plan, which worked really well for him. And now we've got the luxury of having these parties who live less than 2 blocks, I believe, from each other in Kelso, which makes transportation a non-issue, makes the child at 15 and a half, almost 16, able to walk back and forth between mom and dad's. Again, that alleviates a lot of the issue. So that's kind of where we're at. We are asking you to adopt the GAL recommendation, because again, we do believe that's in Landon's best interest, and we do believe this is a young man who's it's time his voice is heard.
Mr. Anagnostia?
Yes, Your Honor, just a brief response with regards to what's gone on in the past. Counsel has brought up all the programs that Mr. Hodges has gone through. Those were to get back into the child's life. He was totally excluded after the assault that he committed on his son, and he had to do certain things to just get back into the child's life. And yeah, he did things. There were periods of time he went a long period of time without seeing him, but that's all in the past, and is not a basis for changing custody at this point. That's what he had to do after the assault charges to have a relationship with his son. And so it's progressed to, my client's the primary residential parent, and he gets alternating weekends and summertime and various other, and that should continue until trial. Here's the issue. This is the issue in this case, Your Honor. The child has an addiction. It's a internet, addiction, electronic media addiction. And my client is working with him on that. And he's in counseling. He has his own individual counseling. They are working so that he can, succeed in school. He's doing okay in school. He doesn't have the, my client is the, you have to do these things before you can get on the internet. You got to study, you got to do these other things, whereas Mr. Hodges is not. So he's in individual counseling. He has been voicing these indications with regards to his father. We think it's because his father is, saying, yeah, you spend more time with me. You can be on the internet all you want. You can, you do whatever. He's not dealing with the issues that their son has, this electronic internet addiction. And so, my client has set up family counseling between her and her son, that is set to occur tomorrow. And if through that, it comes out that he, wants to spend more time with his son, or with the son with his father, I think it should be something that we kind of negotiate, if that is the case, kind of not go from 0 to 50-50, so that the child can be on the internet, every other week, and destroy his grades and various other things. Of course, we're going into the summertime at this point. So that's my client's concern, is he hasn't taken their son's mental health seriously at all. My client has him in mental health counseling, and now she and their son is going to have a counseling session together to try to work out these issues, because we continue to see this as the father being, Disneyland dad offering the son what he wants, which is this internet access. And then they put, things in their declaration about my client being on OnlyFans and, various nasty things to disparage my client. She has been the primary parent through their son's entire life. She did have health issues last year. She had a brain tumor and she had to go through surgery. But she still, takes care of her house, her significant other, their child. She doesn't let him fend for himself. I mean, it's hard kind of not to with a 15-and-a-half-year-old. They have their own schedule, but she's there for him. She's working for him to make sure that he's successful. She has him in individual counseling. They're going to do family counseling starting tomorrow. And we think these matters should be set for trial so we can come in and show the court the significance of Mr. Hodges' kind of manipulation of their son, taking advantage of his addiction. And so that's our request, that there not be any changes, that they go through family counseling. We see what happens there. Potentially, we can work out some increased time. Council and I haven't even discussed that. It's been all or nothing by way of this motion. And so that's our request, that my client's doing the best interest for her son. She's always done that, and she should be allowed to continue that. And that, if they want this major modification of the parenting plan, which a split custody would be a major modification, that we be allowed to go to trial if we can't work it out otherwise through the counseling and various other things that my client's been attempting. So those are our requests, Your Honor.
Rebuttal.
Yeah, and just briefly, I looked through, and again, this is a 4-page declaration that we just received on Thursday. I don't see anywhere where it discusses, and if I missed it, I apologize, a child's addiction to electronics. So again, I guess I first and foremost don't know where that comes from. Now, we would have certainly responded to that as such if that was an allegation. Because, frankly, I didn't see anything pertaining to that or any kind of diagnosis. Secondly, as far as the son's mental health counseling goes, my client doesn't even know that he's in any kind of mental health counseling. So again, if he is, that's news to us. I think what counsel's relating to is the family counseling. So understand the family counseling is set between Landon and his mom to commence tomorrow. As far as the other stuff, again, I'm not aware of that. We would be agreeable to that if that's a request. And again, I would, as counsel stated, the OnlyFans involvement of Ms. Wanzer. If you look at her declarations, it's interesting. She says, "I'm not in OnlyFans now." Essentially, doesn't say anything about the past. This is where a lot of these issues between Landon and his mom started. Because again, we're talking about at the time a junior high child a year or two ago, who goes to school, and his friends start tormenting him again, as teenagers do, about his mom's proclivities on the internet. So that gets back to Landon. Obviously distressed about that. Now that's a lot to try to digest, goes to my client. So if there is any mental health concerns, I'm not sure it's electronics related. I think it's probably more about environment. And again, a child who is at the age of expressing concerns and trying to gain that independence, which Landon is clearly doing at 15-and-a-half years old. So I think from that perspective, the family counseling in between a child and mom is certainly something that's bound to have some kind of positive effect. I think that's terrific. But again, just to say, well, we need to kick the can down to the time of trial. Again, that's not why we agreed to appoint Mr. Lawrence back in the fall. So I think that's somewhat disingenuous to suggest that, especially knowing the trial schedule right now. This is about a 2-day trial, and if we were to set it today, would probably not be scheduled until sometime in December. And the likelihood of getting that continued for court congestion and criminal cases is probably high. So you're kicking the can well out over the course of the year. In the meantime, we've got then a 16-and-a-half-year-old or 16-year-old child who's continuing to be fostering these negative feelings. And nobody wants that. My client doesn't want that. I would certainly assume Ms. Wanzer doesn't want that. And this child doesn't want that. And again, we have various luxuries in this. We have a child who loves his dad, has always been closely bonded to his dad, has a strong network of extended family that care and love him as well. We've got two people who live less than 2 blocks apart from one another in the same school district. So again, we've got a lot of things going for us in this, but these people got to get out from trying to keep the other one under their thumb. And unfortunately, that's kind of my read of Ms. Wanzer's declaration. She's still trying to keep my client under her thumb, and that's not what best for Landon.
All right.
Can I do just a brief comment, Your Honor?
Extremely brief. Go ahead.
Page 4 of Keith Lawrence's guardian ad litem report at the bottom. It says Landon feels he has his addiction under control. He's talking about electronic addiction there, that whole paragraph, but it's in the guardian ad litem report.
Do we have the guardian ad litem present? I didn't hear him.
And that surprises me. I've been infrequent. I don't know if I'm checking my phone now to see if he's messaged me. He hasn't. We've been in frequent communication with this before since that report. And again, that was who I discussed the most recent issues with Landon and his mom several weeks ago. So he's aware. Perhaps it flew under his radar. I can certainly contact him if we want to come back and visit the court, because that's necessary.
Well, I don't think it's necessary. I've seen the report, so I don't think that we need to wait any longer. So I did review the files and record. I did receive the declaration in response from Mr. Anagnostu's client. It's always difficult when children are getting older and they get their independence and the opinions and thoughts that they may have and what things may look like and what's best for that child. And as they get older, the more difficult it can be. The court looks at this. There is no doubt that there is a history of the assault, and that's concerning. At the same time, the court is looking at the dad went and followed through with all the requirements that he needed to do in relation to that assault. And we're looking at 7 years now since that occurred. So based on the files and record, the court is going to rule as follows. As I said, first, there's no doubt it's difficult when there is history as indicated between the child and father. The court recognizes the age of the child, and the court does recognize the guardian ad litem's recommendations is just that, a recommendation. However, the court sees a child that wants to love both parents and not be put in the middle of their dispute. Understand the mom is looking to protect her child, and I get that. With all that in mind, the court is not going to fully adopt the recommendation of the guardian ad litem at this point, but do rule as follows. Once the child is out of school for summer vacation, the parenting plan will be modified to a week on and week off schedule, with each parent having 2 weeks of uninterrupted time as scheduled by June 1. The alternating weeks will commence on the first Friday after school is let out for summer break. Friday exchange shall occur at 6 p.m. This alternating schedule will be for the summertime only and change to the father having every other Thursday after school through Sunday at 6 p.m., as well as every other Thursday from after school to Friday at 8 a.m. So mom will remain the primary parent in this case. That said, the court wants to have the GAL do some additional investigation before the summer is out on how the schedule is working, and the matter is set back before the court for making the alternating weeks as a more appropriate schedule. So for consideration. We won't know until then, but at this point, the mom has been the primary. The mom has been the one that's looking out to what the child is needing. So not making a change to the dad as primary.
And Judge, I'd write as fast as I could you, on those weekend times, Thursday to Sunday, was it after school to what time on Sunday?
Sunday at 6 p.m.
6 p.m. And in the all.
And every other Thursday from after school to Friday at 8 a.m.
Yeah.
So Thursday to Sunday and then Thursday to Friday.
Correct.
Got it.
Very well.
And then, as I said, mother will remain the primary. The parent shall use a parenting app to communicate if they're not already regarding the child. It will be joint decision-making. Exchanges shall be by the child either walking from one home to the other, or if bad weather, the parent with the ending time shall take the child to the home of the other parent. Or if the child's driving, then obviously if the child has a vehicle, can drive. The child shall have liberal but reasonable telephone and or video contact with the parents. The current holiday schedule shall remain in effect. Neither parent is to make derogatory remarks about the other parent. And it sounds like the counseling has already started, so that will continue. And the court wants to have priority over time with the father. So in other words, if there's a time scheduled, if it's every week, the appointments, then the court wants to see that continue. So the child should continue with the counseling with the mother, so long as reasonable. It's not going to be a situation where it takes over the father's time. That's not the intent. That's not to be a negative against mom. I think it's always appropriate to work on a relationship with the child. And the child is at an age where things can get difficult. The request of the father is reasonable, so there will be no award of attorney's fees. Anything I missed?
The only thing that we put in there, and these parties have cooperated pretty well. One of the few issues they've been able to communicate on with 4th of July versus this Thunder Mountain rodeo, rainier days in the past. Now we included that in there. I will discuss with Mr. Anagnostiu, but my client's good with her having every 4th of July if he gets the same amount of time for the Thunder Mountain rodeo. It's been kind of a tradition in the family.
We should be able to work that out.
Very well. And then presentation.
So we can go to June 11th for presentation.
I'm sorry, was that June 10th?
11th.
11th.
I just had the guardian item come on. Mr. Lawrence?
I apologize, Your Honor. I missed it on the docket somehow.
Okay, no worries. I had your report, so if you could just talk to either Mr. Agnostiu or Mr. Zandy about how I ruled. It's kind of a combination of what you had recommended. But I am going to want you to look at the case before, because I did it every other week for the summer, and then more of an extended residential time during the school year. But I want you to take a look at the case again toward the end of summer, just to see how the week on, week off is going and whether that should be what actually continues.
I can do that.
Okay, thank you.
Thank you.
Can you hear me, Your Honor?
Okay, thank you.
Could you let me in on the phone so I have better audio, please? 6829.
I hear you just fine.
I can't. Okay.
All right, Ms. Winkles, go ahead.
Yes, Your Honor. We're here. If Your Honor remembers, we've been here multiple times on discovery issues, multiple times. We've had essentially at the last hearing, Your Honor stated that if everything wasn't turned in by the 14th, that would be it, that Your Honor would not allow any more evidence or any testimony at trial about those missing items. We submitted exactly what was missing. We did receive minor documents, but 90% of what we requested is still outstanding. Ms. Granis keeps saying she's going to get us more. She's going to get us more. Your Honor put a drop dead date. That has not been met. I'm asking because of the fact that there is so much missing and only very little has been provided. I'd ask Your Honor for an order today that states that anything that wasn't given before that drop dead date of the 14th cannot be brought up in testimony. And I will file today a motion to actually exclude this specific evidence that we're talking about, so we don't have to waste the court's time today going through each individual item. But you'll see that February 2nd letter that we attached, 90% of that is still missing. So I just asked for an order that states that Ms. Gronitz cannot provide any further documentation or testimony on anything that was not given prior to the 14th.
Ms. Gronitz?
Oh, excuse me, Your Honor. When I reviewed counsel's submission, I believe she submitted an interrogatory packet of 33 pages. She has since that time received other interrogatory packages up in the 100 and some pages. She has received already all of the evidence necessary for this case that she's seen everything that I have to present on this case. What we're missing is information from her side. I'm missing her information.
That's not what's before me today at all.
Well, if what is before you an issue of whether or not there's additional evidence to be added, the issue I'm having is with counsel's own submissions not matching the problem. So she's arguing or will be arguing her own submissions. So she doesn't really need my information to argue against herself, because the information she submitted to court and the information she submitted to me doesn't match the financial statements that are going under audit. So if the audit doesn't match her court reports, then we have a different issue at hand there. So she's not waiting on information to me to match her own reports to the statements. That's unfortunately the next step. I've had my information audited. I'm going to have to request an IRS audit on Mr. Bop's books because we can't come to an agreement on what's been paid by Mr. Bop or not. And that's where the holdup is. I'm filing a domestic. This is a CIR. This is about property and assets and I've already relinquished my interest in the assets, but I'm still looking to recoup my income for my value on those assets. And that value can't be determined when we have a conflicting civil claim, wage claim, and both of those issues are not matching the statements, and I can't get counsel to agree on values for either one. So they're contingent upon each other. I have two cases contingent upon each other, and I need a third party to come in and audit the information because the information that's presented to court doesn't match the statements. I don't know where else to go from there. I've made a request for the contract of the parties that's in Mr. Bob's possession, or he can retain it via email. Just has to email Daryl Adams, get the contract from November 21st, and provide proof of payment for the wage, the 1099s that he put into the IRS. And he can match his IRS submissions to proof of payments. That gives me a starting point on the civil claim, and then the balance remaining goes on this domestic claim. So that's where I stand. I can't give her any more information because I have no more information to use until this audit takes place. And
Winkles?
Yes, this is just a very roundabout way of saying I'm not going to give it to you. And the fact is that I'm not asking for her to do any work or audit. I'm asking for bank statements. I'm asking for proof of agreements between the parties in writing. I'm asking for any contracts that were jointly signed by the parties. I'm asking for any bank statements or life insurance policies. I'm asking for things, tangible things that I can put my hands on, documents, photographs, things like that. I'm not asking for Ms. Gronitz to go through anything. She knows that. We've been here 6 or 7 times in this case alone and 6 or 7 times in the last case. I'm asking for the same items. They're not forthcoming. I can't set a trial unless I know what she's going to present. She refuses to give it to us. She keeps saying, you're waiting for my auditor. Well, this case has been in play and these have been requested since September. I'm not sure why she can't have had that done, but I don't need her to audit it. I need the documents and then we'll have our expert do it and her expert can do it. And that's great. She hasn't even disclosed an expert. So I don't know any of this. I'd ask that essentially anything that wasn't given prior to the 14th be excluded, and acknowledging that I will be filing a motion to exclude specific evidence because it's too long to go through today. And I will give Your Honor a giant packet, unfortunately, of all the stuff that has been provided. Very little of it is useful. Most of it is like things from high school that she had, things about her mother, things that her children drew. None of that I need. I need very specific items. Ms. Gronitz knows this. If she's smart enough to handle most of this and to do audits, she's smart enough to answer the interrogatories and provide the documents that I've requested. So I'd ask Your Honor to exclude her testimony and any further document submissions from her.
Ms. Gronitz, you have continually said that you can't provide what has been requested because you need to audit. You need an audit. You need an audit. That is not what this is about. This is about turning over hard documents that you have in your possession or control, and that has not occurred. You continue on this route of, well, I need to do an audit. No, you do not. You need to have turned over the documents as requested. So with that, I will grant your requested relief, Ms. Winkles. Get me an order and I'll sign off on it.
All right, thank you.
Is there an email agreement on this case? I believe that might be our gap in information, Your Honor, because I've emailed this information. She has 1,200 documents in her possession. Per zip file drive, I have 40 requests for production folders she's been sent.
I don't know what to tell you at this point. Ms. Winkles, an officer of the court, is saying that she's not received it. So if you emailed it, then you're going to have to file proof of that to Ms. Winkles. But that's it for today.
Thank you, Your Honor.
All right, the court had directed the turning over of documents. That has been done from what I can see. This really wasn't a discovery issue as much as the documentation of what I was looking at as far as the contempt matter and the motion for temporary orders. So the motion for temporary orders was by the respondent. I've reviewed that, and so, Mr. Jackson, anything further on that request?
Just that we requested that we have mediation and she refused.
Okay. So Turn off your camera and back. You're not to record these proceedings. Shut it off.
I'm not recording.
Then get rid of the camera.
I'm not recording.
Get rid of the camera. Ma'am, bring it up. Bring it up and get it back when we're done. No. All right, so going back to the temporary orders, ma'am, anything you wanted to say in regard to the temporary orders?
No, not at this point, no. I'm
Okay.
more worried about the content.
Okay, so in regard to the temporary orders, this matter has been before the court twice on temporary orders already. The issues that have been requested for a third time have already been ruled on by the court. So the court is not going to be doing another ruling that changes what prior courts and judges have ruled on that. This is the court understands respondent may not like how the court had ruled in September 23, but the court finds these orders stand. There is no showing of change in circumstances that has been shown or verified by the respondent. As well, the request for the restraining order is denied. So in regard to the temporary orders, that is denied. That brings us to the request motion for contempt. And so this is your motion in regard to the motion for contempt. Anything you wanted to add on that?
Well, he finally had ended gave me all the paperwork that has been requested by you and also by me. We are missing a few months of statements for our joint account on our service public credit union. And he also filed showing taxes on us for 2023. And I was trying to file taxes and I got my taxes denied because he had filed them already with my social security number. So, yeah, I mean, what I do want is I want my house back by the end of the week. And I want to get him started on the spouse support that he passed paying me. I haven't received anything since February. So that gets him at this point of over $22,000 on back support. I've been sleeping still on couches. The car broke down. I had to borrow for my kids another one. I'm like at my end's with. I had emergency surgery 2.5 weeks ago. So yeah, I just want finally getting all the stuff that was ordered in the judgment on 9/12 to be done, which means he needs to move himself out of the residency and start paying me my spousal support.
Counsel?
Yes, thank you, Your Honor. There's no doubt, obviously, that this is a contentious proceeding. Nonetheless, this is the petitioner's motion for contempt, and asking to put a man in jail over financial noncompliance is a pretty steep slope. It appeared that your court found that the documents were produced responsibly. I submitted an affirmation as well, just outlining the basic facts of which documents I saw were produced by my client. In short, my client comes nowhere near the standard that he should be held in contempt. Regarding the petitioner's other things, again, I'm not the family law attorney here, but if she is upset with some of those things, the items, in short, that's the trial realm. And we're arguing very narrow here whether my client should go to jail. And that's a high bar. And under the case law in my briefing, which I won't, provide the court further, my client should not be in jail. He has complied in a good faith compliance here. And if there are other issues, are basically our family law court rules and are the remedy, and she can motion appropriately. But at this time, again, my client should not be put in jail, Your Honor. Thank you.
Ma'am, anything further?
I will waive the contempt of him going to jail if he is willing to finally move out of the house as ordered on September 12th. Is he finally starting paying spousal support? I will waive the contempt. I will waive the whole jail time, but stuff needs to get done. I need to get off the couch.
So I reviewed the files and record. I went back and I looked at the prior orders, and based on those files and record, the court finds the following in regard to contempt. Court does find the respondent in contempt of failure to pay maintenance as ordered and was so done in a willful and intentional manner. The court grants a judgment in favor of the petitioner for $1,600 per month from July 1, 23 through August 31, 20. That would be 23 as ordered on July 18, 23, and $3,000 per month from August 1, 23 to March 1, 24 as ordered on September 12, 2023. This respondent can purge the contempt by immediately resuming the payment of maintenance as ordered plus $300 per month toward the judgment of the total back due amount. The judgment shall carry interest of 12% interest. The court is not considering putting you in jail at this time, but you need to understand that you need to come in compliance with not only one, but 2 court orders that have been made in this case that you have completely failed to follow. In regard to the moving from the house, you are to remove from the house by June 21, 24, which is substantially past the due date that you were ordered to exit the home back on September of 2023. You have failed to do this. If you have failed to do this, then the court will consider a contempt motion and possible jail time. You have totally ignored the orders of this court, and I expect you to comply with the orders as previously ordered. And what I did see by the financials is that you had substantial sums. Rather than pay the petitioner as ordered, that money seemed to have just disappeared. I have no idea where. I don't know anything about that, but you certainly had the means in which you could have paid her the maintenance as ordered. The parties are going to be set on the universal trial assignment docket for June 12, 24, where the case will be set for a 1-day trial to get this case done. Coming back and back and back is not the way to resolve a case. If she doesn't want to do mediation, that's her choice. This matter is going to be set again on June 12, 2024 for getting this matter set for trial. This case needs to move forward and get done. You'll need to prepare orders that reflect my ruling. So we'll go ahead and do a presentation on, let's go ahead and do June 11 at 9 a.m. And you'll need to get your proposed order to Mr. Lee so that he can see that it reflects my ruling.
If I may, Your Honor.
Go ahead.
And Ms. Jackson, technically I'm addressing the court, but also to you. I'm more than happy to facilitate based off of the fact that I have access to the court records and minutes. I'm more than happy to assist drafting that order to reflect in the interest of making sure that it's a smooth presentation on the 11th. So please, you have my contact information, but bear that in mind.
So let me just explain.
Yes, sir.
You can contact Mr. Lee. It sounds like he'll draft the order.
Okay.
And that way you can look at what he's put together. Obviously, as an attorney, he has the knowledge to do that. Appreciate that, Mr. Lee. And then on June 11, it'll be presented to reflect, again, what it is that I've ruled. Okay, that's what it's about.
And just a brief procedural matter, Your Honor, after the presentation order, are you satisfied if I just submitted ex parte a motion to withdraw given the
That's
contempt?
fine.
Thank you.
Thank you.
Your Honor, I have just one question. So is on the June 12th, we're gonna have the trial?
No, that's to get a date for the trial.
Oh, okay, all right, thank you.
Yeah, and that's okay. So I have a few different dates here. So June 11 at 9 a.m. for the presentation of the order. June 12 at 9 a.m., that's via Zoom, it's not in person, is to set the trial for a one-day trial. Is she now on that docket? So is she on that docket now? Can you put her on that docket? June 12th?
Yes.
Okay, thank you. And then the date by which Mr. Jackson is to exit the house is June 21, 24.
Thank you. Would you just for my notes as well, just repeat the amounts from your prior orders that Mr. Jackson owes?
So in regard to $1,600 per month from July 1, 23 through August 31, 23, as ordered on July 18, 23. And $3,000 per month from August 1, 2023. So that doesn't make sense. You'd have to go back and look at the order of September 12. I'm not sure when the 3,000 began. I think it's 9/1.
9/1, yeah.
Yeah, so 9/1. 9/1/23 to March 1, 24. And ma'am, so you understand, I stopped the judgment amount at the time that you filed your motion because that sets the amount requested.
Yes. No,
So if he continues to not pay, it would start from that time forward.
Okay,
Okay, just so you understand why the judgment isn't till today's
okay,
date.
yeah, no, that's fine.
And then $300, the $3,000 per month plus $300 per month toward the judgment. So 3,000 regular, 300 per month toward the judgment. 12% interest. 28-08.
That matter's ready.
Noel McLean appearing on behalf of the petitioner, Rachel Kaufman.
All right, counsel, go ahead.
Thank you. For the record, I'm Chelsea Baldwin and I represent Justin Kaufman. This is our motion to modify the temporary orders. In this case, we're asking the court to eliminate spousal support and make it clear that both parties are responsible for their own vehicle and vehicle insurance payments. These parties have been separated for more than 2 years at this point, and my client has paid spousal support for 2 years or more than 2 years at this point. There's been a significant transitional spousal support that's been paid during that period of time. And the reality is that the transition has occurred. The purpose of transitional maintenance has been achieved. The transition between dependence and independence has happened. There's no continued basis for support. Originally, when these parties separated, there was a community property home with all of those normal household expenses. Mrs. was living in the home. She was obligated to pay not only the mortgage, but maintain the home, pay the taxes, the insurance, all of the other things that are that come with home ownership. That home was sold, so that obligation no longer exists. No longer exists at this point. The petitioner had a lower paying, I believe it was part-time at that time job. She, at the time we filed, had a full-time job making just about $20 and a half per hour. That was her probationary wage. We believe she's actually making about $21 to $22 per hour after her 90-day probationary period. So again, significant change in her employment. Now she reports in her response like, well, hey, in literally the weeks around filing this motion, now I've entered this training program. But the reality is that her wages aren't really changing at all as a result of that. And this training program doesn't make any sense. It's not schooling. It's not education. There's no tuition. There's no books. There's no cost. What this really is it's a business that's filling its own need. It's a business that says, hey, I can't find people to staff these positions, so I'm going to create this training program to fill my own need, which is fine. Businesses can and should do that. But it's not education in the traditional or even really a non-traditional sense, and not one certainly that my client should fund. Additionally, the reality is that it doesn't result in any increase in wages for her. This is sort of a shot in the dark of, I'm going to claim I'm in school, so therefore I need continued support. And I'm going to do this at the 11th hour. Sort of the settlement conference didn't work, so now I'm going to enter this program and claim at school. But it's not. And we know that because her wages aren't going to increase. We show you what her wages are now at Fiber Federal, which even in her probationary period, were again that $20, $21 per hour. And after 2 years, she could only hope to make $23 an hour after having done 2 years of this program. That doesn't make any sense. During that same 2 years at Fiber Federal, she could anticipate making the same type of increases that would bring her to that same $23 an hour. So this isn't education. It's not training. This is just really a lateral job move for her. Again, moved from part-time to full-time. She's fully employed, fully employable, and she's capable of meeting her own needs. Critically, she is cohabitating with another person. She is sharing those expenses, and she's engaged to that person. So, and she doesn't deny any of that. This is the same person she's been dating since November of 2022. So this is a long-term, stable, committed relationship between these two folks. He's written declarations into the court record for her. So again, that indicates sort of a level of commitment and stability for her. And these folks are sharing expenses. She says, "Oh, that this just happened." My client says, "No, that's not real." I would argue she just got caught. That's why she's admitting it now, because there was no denying it at this point. But even she admits that she has a surplus of funds every month. And she uses those surpluses to take fun vacations. Good for her. She's going to Hawaii. She's going to Arizona. She's taking other trips. That's lovely. My client, on the other hand, is not sharing expenses. He's the only one in his household. There's no other adult in his household that is sharing expenses for him and with him. So again, we have someone who's very much moved on financially, but also in a very much practical sense. When we look at other expenses that these parties had when they separated, when the home sold by agreement and by court order, all of those expenses were essentially paid off. So there's no community expenses that Mrs. is still paying. They were all paid off. So all the credit cards were liquidated. Everything was paid down to zero. So any type of expenses that she still has, those are all things that she's done post-separation. So as far as sort of obligations and those types of things, they've all been brought down to zero. So again, the need has been brought significantly lower. And the reality is that these people are just living separate financial lives in addition. Mrs. went out and purchased a new vehicle. She wrecked her last vehicle that was a community vehicle. There was a surplus of funds that came out of that. She rolled that into a new vehicle, bought herself a nicer vehicle. That's great. But you note that she insured it herself. She paid it herself. She never asked my client for payments. And while she desperately tries to blame him for that on the back end, the Our Family Wizard record tells the tale. Where my client says, "Hey, what's up? I see that insurance is taking you off." And she says, "Yeah, I did that myself. It's just you now. It's not my car." She did that herself, wholly on her own. That was her choice. And that's because they're living separate financial lives, as they should after 2 years. It's very reasonable that these folks have moved on practically and financially. So at this point, the court should end support. There's no basis to continue it. She's self-supporting. She has another adult in her home that she's engaged to and sharing expenses with. There's a surplus of funds. She's taking vacations. It's just not reasonable at this point to continue support. The court will, as a result, need to adjust child support. We've provided a child support worksheet that reflects their actual incomes, and we're asking the court to adopt that. By adopting that new child support worksheet, that puts a transfer payment of $1,839. That's still a substantial transfer payment that's going to occur. My client will continue to cover the children's medical premium costs. My client agrees to continue covering her medical premium costs. So he's not going to drop her off of medical insurance. That would remain until these parties complete their dissolution at some point. My client is asking for each party to claim one child in taxes going forward. So for the 2024 tax year and until this case resolves. And we're asking for the order to be effective May 1st. This was filed April 30th. May 1st as an effective date would be reasonable. So in this case, given all the evidence, and there's substantial evidence to support this, we're asking the court to end support, make it clear that essentially validate the fact that these parties have for about a year or more managed their own vehicle insurance, managed their own vehicle payments, make the new transfer payment $1,839. And we're asking the court to deny any requests for fees from the other party. That's just not reasonable given the circumstances that we're in.
Ms. McLean.
Thank you very much, Your Honor. So as I indicated at the top of our hearing, I do represent the petitioner, Rachel Kaufman. I guess my initial reaction is to point out to the court that we currently have 2 trial dates set. The first trial date is set for the first week of September this year. A backup second trial date is set for the first week in February of 2025. And I see this basically as an attempt to piecemeal this financial aspect when there's certainly factors under the statute that are to be considered. I think it is appropriate for a trial court to be able to hear all of the evidence and the information relative to these parties' financial circumstances. We've done our best to point out those historical issues to the court, but just to indicate, first off, we think that this needs to be heard at trial on the full merits of the statute and the factors from both parties. Mr. Kaufman, it's undisputed, has been the breadwinner for this family. He has consistently and significantly worked. And one of the factors for spousal support is the fact that my client has been there to support him to be able to pursue that. And she's done as he's requested by being available at home and taking care of the children. When the children entered into school, she held some part-time jobs. At the time that these folks were separated, she was holding a part-time job across the river in Rainier, Oregon. She has recently transitioned late in 2023 to Fiber Federal Credit Union for a potential opportunity to work there. The suggestion that she has overtime or was working 40 hours a week, with the way that Fiber Credit Union works is that they downplay overtime. That's not something that they want to pay. And it's borne out by my client's wage stub that shows year-end 2023 that she had $38 in overtime. The only time that she was working overtime, the only time that she was working 40 hours a week with Fiber was during her training. Her initial training, I believe, was 2 weeks long. She then was given a work schedule. And again, it's borne out by her wage stub that shows she was working about 30 hours a week. So in 2023, you'll see that Mr. Kaufman grossed $181,000, not including the back pay that he received for the Longshore Union contract negotiations that paid him, I believe, an additional $35,000 that year. But my client grossed under $34,000 that year. Ms. Kaufman has been working. She's not asking for him to foot her entire bill. But you have to keep in mind, Mr. Kaufman has been a longshoreman for a number of years, that they are accustomed to a lifestyle. And the suggestion by counsel that he's going to keep my client and the children on longshore health insurance and pay, the employee, the longshoremen do not pay. That is a complete benefit. They have the gold standard in health insurance. So he doesn't pay anything extra to keep her and the children on the health insurance coverage. But his income is 5 times her income, and this is a midterm marriage at 13 and a half years. So when you take a look at the statutory factors, that suggests and speaks to him providing support for her, not just for transitory periods of time, but also taking into consideration their lifestyle, each of their respective roles, her need, his ability to pay. It's uncontroverted that he has at least $2,000 per month disposable net income, even with paying all of his claimed expenses. The suggestion that he's not sharing expenses with his father, and quite frankly, his father's declaration that was filed is quite misleading because his father purchased this home on 2139 Grove Street on April 24th, a little over a month ago. Otherwise, he's been living with and sharing expenses with Mr. Kaufman this entire time. And that was something that the court took into consideration when the court was ordering, did not take into consideration when the court was ordering the spousal maintenance that was effective December 1 of 2022. So he's paid a little over a year and a half of spousal maintenance at this point on a 13 and a half year marriage where he's making 5 times her income. Her monthly expenses currently are $6,475 per month. And unlike Mr. Kaufman, who has received substantial monies in those negotiated contract arrears that allowed him to pay off all of his community consumer debt, my client is not debt-free, and she continues to have community consumer debt that has not been paid. That being primarily this vehicle. It was not my client's choice to get into an accident. The amended temporary order was clear that in conjunction with spousal support and child support, Mr. Kaufman was to continue to pay my client's automobile payment and the insurance payment. He knows that because, one, we sent correspondence to them after the accident that provided the updated insurance information as well as the updated car payment. we made a request for him to pay, and those are in exhibits G and H at pages 26 and 23 of, 26 through 33 of the attachments. And he has provided not 1 cent of a payment, but he's here asking the court to modify that order. So he knows he's supposed to be making payments. We made a demand for payments and he's not been paying that. Currently, because of his, again, willful failure to make payments as court ordered, he currently owes my client $8,028.52 in automobile and automobile insurance payments, plus outstanding interest of $552.94. And we're asking the court to enter a judgment. If you go back and look at the history of this case, Mr. Kaufman previously was ordered to pay utilities and other expenses on behalf of my client and the children. He failed to do so. The court previously found him in contempt for failing to pay almost $1,000 in expenses. So this is not a one-off for him. He continues to try and financially abuse my client, and that's why we're here with this motion at this time. My client, contrary to counsel's argument, is attempting to secure an education that will provide her with a wage to be self-sufficient. When she moved she worked with Fiber until she was accepted into this program. It is to train her through the business itself, as well as for her to attend online classes every Monday. And there are books and costs. Once she signs up for that and is accepted to the program, and actually she's been accepted to the program, once she starts that program, then she will be able to see what those costs are. She will be doing online courses every Monday for the next 2 years. She will be doing on-the-job training for the next 2 years. And as a result, she's going to be working 32 hours per week, grossing approximately $2,900 per month, which puts her at a net of about $2,500 per month. The suggestion that her monthly expenses can be met by that amount and $1,839 per month is not borne out by the evidence that we provided. And again, I think that there's factors that a trial court, once you had the opportunity to flesh all of this out through testimony, that the court would continue ongoing spousal support for Ms. Kaufman. We're asking the court to deny the motion. We're asking the court to grant a judgment to my client for the arrears. We're also asking that the court order that those amounts be paid within 45 days. As a longshoreman, Mr. Kaufman can easily obtain a personal loan through Longshore Federal Credit Union. He's debt-free, as he indicates, and he can pay that to her within the next 45 days. It's our position that this has not been brought in good faith since we have trial dates pending, and that they're attempting to piecemeal without my client being given a full opportunity to present evidence and information before the court. The court does need to hear all of the evidence and information. And again, keep in mind that my client remains the primary parent for these children. So she's a household of 3, providing for her and her children. In regards to her future income, I would suggest that that's speculative because the information that they've provided is based on somebody starting and doesn't take into consideration if they've gone through this training through their facility and online training. I would also submit that the allegation in regards to my client's vehicle being new, it is a used, if I recall correctly, 2015 vehicle, so it's new to my client, but it is a used vehicle. And there was roughly $9,000 that transferred over towards that debt, but there was still outstanding debts that were satisfied by the insurance company. And had the vehicle not been totaled, Mr. Kaufman would have still been paying that vehicle debt, and the order is clear that he's to pay her vehicle. I do believe that the taxes issue is premature. We don't know parties' incomes, and again, we've got, as far as at the end of the year and what potential expenses there are, that's something that should be decided again by the trial court, whether it be in September or February. That will be sufficient time for the court to make appropriate orders as it relates to taxes. So we're asking the court to deny the relief, order the judgments, and award my client $1,800 in attorney's fees for having to be here.
Ms. Baldwin?
Thank you. In this case, you have just a significant amount of information and a significant amount of evidence to base this decision on. This is not 1 item or 2 items have changed. This is basically everything that the court based its temporary order on has changed and changed significantly. and they're aware of it, and their only tactic is delay. And it was true when it was first said, and it's still true today, that justice delayed is justice denied. The court's well aware that it cannot guarantee us a trial date at frankly almost any point, that trial dates are wildly uncertain. And so it's reasonable that we come before the court. The court can also at trial say, hey, I disagree with what happened, and I'm going to restart maintenance, and I'm going to put it back to whatever date it wants. The court can also do that. But that's not what they want. They want the court to just not do anything, but that's not justice. In this case, they don't deny that my client voluntarily paid since separation and then paid per the court order. So they want to make it seem like he's paid for less than he has, but the reality is he's paid for more than 2 years at this point. That's a significant period of time. The children involved here are not young toddler-age children. We have a teenager and a 10-year-old. So we have older children. We have Mrs. moving from part-time to full-time work, making independent choices. I would argue they're not wise choices, but she's making independent choices. There's nothing that she has from Fiverr saying that she's not going to get full-time wages and full-time work. And we didn't base our accounting nor our child support worksheet off of her receiving any overtime. We said, hey, it's clearly available. You can see it. You can see it as a line item for her, but we didn't base anything off of her receiving any of that. Again, when you look at her ability, she has the ability to make her own, to pay her own way and to meet her expenses. And she's not only doing that, but she at this point is receiving so much support that she's taking these significant trips. These trips to Hawaii, these trips to Arizona, these trips to other places. These are significant. It's not, and she's doing that while she's sharing a home with another person, with another man who she's already engaged to. And that's kind of where the line starts to really break, is once you're engaged to another person, that's sort of some reality checks need to come into play. Counsel's incorrect when she talks about the vehicle. It's a 2019 vehicle. About $10,000 was placed from the community funds were placed to pay for that vehicle. But Mrs. chose that vehicle. My client had no say. She could have probably found a free and clear vehicle for that same amount of money. She chose not to. She wanted the car she wanted. This was a year ago, so this is only a few years old vehicle. And so she got what she wanted, but it's a higher cost. And then she independently pulled herself off the community insurance. Again, my client's not obligated to go and say, hey, I'm going to pay for whatever insurance you want to set up. And that's not what the court ordered. Desperate to just muddy the water. They didn't bring any motion for a judgment because they know they wouldn't get it, because the court order underlying this is very clear on what he was supposed to pay for. So that's not before the court, but they didn't bring that motion because they know it would be denied and because it would be inappropriate. And so again, she could have been debt-free. That's her only debt, and it's one of her choosing. So in this case, and then finally on the issue of taxes, what gamesmanship? And my client says, I'm tired of the game. Please don't make me play the game with them and just order one kid to each party so I don't have to deal with the gamesmanship of them sort of, I won't let you file your taxes until you give me something. And their pleadings, they say, oh, it could have been worked out so easily and you should have to pay fees for not working it out. And then they come to court and say, oh, we refuse to work it out at all. That's gamesmanship. We shouldn't do that. That's not a hard call. There's 2 kids. That's very simple. And we shouldn't be using tax exemptions and people's ability to file their taxes as a lever. That's just not appropriate. So in this case, we've given the court a significant amount of evidence that supports my client's requests. We're asking the court to enter the orders that we've proposed.
So counsel, I have one question. The house was sold. What happened to I don't recall. I want to make sure that I'm remembering it correctly.
The money's just sitting in my trust account.
That's correct.
All right. So I did review the files and record, and here is what the court is going to do. The court does find some change in financial need, but very minimal at this point. I understand there's someone sharing costs, and at the same time, trying to know all the evidence that would support a claim for maintenance is unknown. So that's one thing the court is trying to weigh. The other thing is that the mother is working more on a full-time type of basis. And so there needs to be a consideration of that when it comes to child support. So with that in mind, the court is, let me look at something real quick. In regard to child support, at the time it was set in accordance with the parties were making and capable of making under the temporary orders now. So in regard to the income of the father, the gross will be set at $14,928 per month, and that is gross. With the deductions that need to be made, it's a net of $11,129.51.
I'm sorry, would you repeat that, please?
So the gross is $14,928. After
Okay.
deductions, $11,129.51.
All right.
What I don't know for the mother is, I didn't calculate this out, but it's $21.25 per hour, and I'm going to set it for a 35-hour week. So I'm essentially imputing 5 additional hours and figuring out what that is. That I didn't do.
We can do that.
Okay.
Well, and we did provide the contract from the agency where it identifies her hourly at 32 hours a week because she's only going to be working Tuesday through Friday.
Right, so I'm imputing 3 additional hours. I'm setting it at the 35 hours.
Okay.
So child support needs to be figured out as to what that amount is first. As far as the taxes, each parent shall claim a child for tax purposes, father the oldest and the mother the youngest. That may be ultimately changed, I don't know, but at least for now, that's what it's going to be. As to the auto payment and insurance for the car, again, this is where the court does find some changes that have occurred since the original order. So the petitioner shall pay the auto payment and insurance for her car, subject to reimbursement if so ordered by the trial court, but that's by the trial court. But for now, she's going to pay it, and the respondent shall pay the payment for the 2015 Honda Accord. Each party is to pay insurance associated with their vehicle.
Okay, I'm sorry. So did you say she is to pay the auto and car
So
payment?
I want her to pay her auto payment and insurance for her car, subject to reimbursement at the time of trial.
The trial court will determine if reimbursement is
And that starts when?
Whenever she had the new, call it a new car, what her is now the car that she has.
So the court is retroactively then adopting that to June 1?
Correct.
And then, so you're reserving that retroactive application from June 1 to present for the trial court?
Correct.
Okay, I just wanted to make sure. Thank you.
All right. As to the maintenance, what I want is to have you figure out what the total is of maintenance and child support now, refigure the child support. So ultimately, it's the same amount that's going to be continued to be paid by the husband.
The $3,000.
Well, I don't know what it is.
So right now the order is $1,800 per month child support and $1,200 per month spousal maintenance for a total of $3,000.
Okay, so figure out the 3,000 less the new child support amount and the difference between those two to equal the maintenance.
Okay.
That's to pay. So it's the same amount to continue to pay. However,
reallocating.
Right. So however, the payment is subject to reimbursement if so ordered by the trial court. So if the trial court determines, and that's where I agree that I think there are more factors, I think there's more information. So the court at the time of trial may determine that she should not have received this ongoing maintenance, and that can be reimbursed at that time. That makes sense?
Yes.
Okay. All right. There shall be no changes to any medical health insurance policy that covers either spouse, domestic partner, or any child. There shall be no change in the beneficiary of any policy. So the father will continue to, or husband shall continue to pay the medical, the insurance that he's been paying or has had paid through work.
For her and the children.
Correct.
Right. Okay.
Okay.
Attorney fees?
So in regard to attorney's fees, the court is not going to order attorney's fees at this time. I think there's been a change. I think it's appropriately brought before the court. And so no attorney's fees.
Okay. Presentation?
So we can do it on June 11th?
I can do June 11th.
Yeah, I think I've already got stuff on June 11th. Yes. And you're aware that that docket's closed? That was closed on May 24th.
No, I'll go ahead and add
sorry,
it
May
to the 11th. I think the numbers have changed since then is the problem.
Okay. So June 11 at 9 a.m.
Correct.
Thank you.
All right.
Amy Powers here on
Yeah. Let's
behalf
close
of the
it.
petitioner Heidi Stevens. Ms. Stevens is present with me in my office today. So we are here today on the petitioner's motion for temporary orders, and the parties began living together in September 2016, married July of 2017, and separated last month, April 19th, 2024. Ms. Stevens has one minor child from a previous relationship, Carter, age 16. I'm just going to go through really quickly and summarize for the court the areas that I believe we have agreed between the parties. In terms of spousal maintenance, my client is not actually asking for spousal maintenance. She's asking that the husband be allocated to pay the mortgage on the home. So maintenance is not an issue today. Both parties agree that the court enter a provision, a protect the property provision, where neither party will move, hide, sell, or get rid of any of the property. I believe that the parties are agreed in terms of debt allocation. Both parties will pay the credit cards in their names. Mr. Stevens' proposed order did include a Chase card that Ms. Stevens would be appropriate for or responsible for. Ms. Stevens provides for you. She does not have a Chase card. She only has a Citibank card, but she's happy to pay her Citibank card. In terms of the insurance, my client agrees with Mr. Stevens' proposal that both parties be responsible for the insurance on the real estate that they're responsible for and the autos that are ultimately in their possession. In terms of attorney fees, my client is not asking for attorney fees on a temporary basis. That can be decided by the court at finalization. I believe both parties are agreed that my client will continue to collect the rental income and manage the rental properties and can provide that accounting. And then lastly, I believe that the parties are agreed that Mr. Stevens will remove his name from the Fiber Federal Bank account that my client's been primarily using. So those are the issues that are agreed. In terms of the disputed issues in front of the court, I think the biggest issue in front of the court right now is who will continue to reside in the family home. Both parties indicate for the court that they would like to live there. My client explains that her and her kids have lived in this home with Mr. Stevens for 8 years. There's been a substantial community contribution to this home, and both parties are listed on the title. The child, Carter, is almost 17 years old. He'll be 17 at the end of this month, and he's finishing his junior year in high school. Carter is fighting brain and spine cancer and has recently learned that this cancer is
I guess I would object as to the hearsay information.
Both parties' declarations include the fact that Carter is fighting cancer.
You're objecting to that information, Ms. McLean?
No, I'm objecting to counsel's next information that I anticipated she was going to be arguing relative to the allegation that it doesn't affect his behavior.
Oh, that wasn't where I was going.
Okay, so go ahead.
Thank you, Your Honor. So Carter is currently fighting spine and brain cancer and has learned recently that cancer is not curable. This is a big issue for my client, is supporting Carter and his needs. Carter needs to be in a situation where his stress is minimized. And the declarations lay out for the court that there were some incidences in March that led to Mr. Stevens requiring Carter to leave the home. Carter went to live with the maternal grandparents. It was intended that this would be a very short stay and that things would be able to be resolved with Mr. Stevens. They were not. So Carter has continued to stay with his grandparents at this period of time. The grandparents submitted a declaration that their home is too small for Ms. Stevens to move into. Given Carter's age and also his health issues, it is imperative that he reside with my client. And given Carter's health conditions, it's very important that his stress be minimized. We are asking that the court allow my client and Carter to continue to reside in the home on a temporary basis until we can get to a final resolution in this case. There is no room at the grandparents' home for both my client and the child to live, and moving is going to be harder on Carter than it will be on Mr. Stevens. Mr. Stevens was out of the home for a short period of time, and Carter was able to return there. This has been Carter's home for the last 8 years. It's where this family has lived and grown, and we ask that my client be allowed to be back in that home. The long-term hope is that my client will be able to purchase a new property and be able to move one time with Carter. But at this point, she is not able to do that. And so if she's not able to move in the home, it's going to necessitate at least 2 moves, a temporary move now and then a permanent move down the road. We're asking instead that Mr. Stevens be out of the home. His parents do have a guest room where he can live, and it's easier to house one person than it is to house 2 people. Ms. Stevens' parents are living in a rental home owned by both parties. They explained to the court that they've lived in this home since September of 2018. They paid for improvements to the property. The home is only about 1,500 square feet. They do have 1 guest room with a bed. That's where Carter has been staying. But again, as has been mentioned, there's not room in this home for both Ms. Stevens and for Carter. So that is our main request, that Ms. Stevens be able to reside in the home. The next issue before the court is the use of property. The parties have substantial what you might consider toys in terms of boats, trailers, side-by-sides. And we're asking that my client be able to maintain possession of the Buick Enclave, the Subaru Impreza, and her dog, and that Mr. Stevens have his Jeep and his personal property. We're asking that the remainder of the items remain at the home unused by either party. This will save money in insurance. Additionally, both parties have alleged in their declarations that each party has already removed some items or changed some assets. While Ms. Stevens denies that allegation against herself, she has provided information to the court, including pictures showing that Mr. Stevens has removed some items from their property already and has emptied their safe. We think that it makes the most sense to protect.
I would object at this point. That's new information and allegations that Ms. Stevens could have raised in her initial pleadings. My client has not had an opportunity to respond to those allegations or the photographs that we just received the clear copies this morning. So I would ask that the court not allow argument relative to those new allegations.
And I would ask that the court allow it not for the purpose of deciding whether or not the truth of the matter asserted, but to weigh in terms of protecting property going forward.
So at this point, I agree in part that Ms. McLean has not had an opportunity to respond, but I will just essentially weigh in. I'm not holding it against your client, Ms. McLean, just simply understanding the need to take care of the property. That's all. Go ahead.
Thank you. So that is our request in terms of use of the property. The next item that's contested is the household expenses. Ms. Stevens would like to pay for the utilities in the home and any future insurance and taxes for the rental property. She's asking that Mr. Stevens pay the mortgage, homeowner's insurance on the home, and property taxes. Mr. Stevens has also requested that the parties separate their cell phone plans, and Ms. Stevens agrees to this, but asks that Mr. Stevens pay off whatever is left remaining owing on his phones and his kids' phones so that she won't be left responsible for that when they separate. Both parties have provided financial information to the court, and what we see is that the mother grossed about $97,000 in 2023. She provides information to the court, letting the court know that due to Carter's medical issues, she has had to start taking FMLA and unpaid days at work. She submitted her projected pay stubs for the next 5 months based on the FMLA she's already requested off through her employer, and that reduces her income approximately $780 net per month. Over the last 2 months, Ms. Stevens has paid all of the community bills, and additionally, she has medical bills that she's paying for Carter. Mr. Stevens asserts that Ms. Stevens has been receiving child support. My client provides for you the printouts from Oregon DCS showing that she has not been receiving child support for the last several years. There was a recent order where she might begin paying child support in the future, but even Mr. Stevens in his own declaration indicates that during the relationship, child support was not regular from Carter's father. On the other hand, Mr. Stevens grossed $165,000 in 2023. He does show pay stubs and expects his income to be a little bit lower this year. But accordingly, we would ask that Mr. Stevens be responsible for the mortgage on this property, regardless of who is residing in it. He is in a better financial position to be able to do that. Lastly, the issue of the security system has come up. Ms. Stevens is asking that if she be allowed to stay in the home, that she have exclusive access to the security system and videos. Mr. Stevens in his declaration asked that the mother's access be denied to the security system. Although Mr. Stevens puts that in his declaration, he did not wait for the court to make a ruling on this matter, has already removed Ms. Stevens' access to the security system. So we would just ask—
I guess I would object. That's outside of the scope of declarations.
The security system's in there. What?
As far as her removing him?
I believe we did make that request in our motion.
I don't see that in the reply declaration. These
The initial motion made the request that whoever was in the home would have exclusive access to the security system.
Okay.
So that's
I just heard counsel argue that my client has recently removed her from the system. And I don't recall seeing that in there, just that she was asking for use of that.
Ms. Powers?
I thought that it was in our reply declaration, but it may not have been.
Okay, go ahead.
But either way, we would ask that whoever is allowed to remain in the home have exclusive access to the security system.
Okay, go ahead.
Thank you
Anything
very
else?
much. Oh.
Anything else?
No.
All right,
No.
Go ahead, Ms. McLean.
Thank you very much. Again, in support of Mr. Stevens's request as a respondent, he identifies that these folks had separated in March of 2024. You actually have text messages that are provided by Ms. Stevens in her responsive declaration that supports the claim of those discussions in March of 2024. And I would also note that at this point, this is a short midterm marriage of 6.5 years. So the reality is that the court is likely tasked with placing the parties back in the position that they were in at the time of the marriage, and then allocating for community assets and debts. At the time that these folks married, my client had purchased the property of the Wool Road home in 2008, and he built his own home in 2008. That's what they're identifying as the family home. So this was about 9 years before their marriage. So he came into the marriage with his built home, his vehicles, bank accounts, pensions, and the like. Ms. Stevens came into the marriage with substantial attorney fee debt, 2 children who were not supported fully financially by their father. And ultimately, there have been 2 homes that have been purchased, both of which are free and clear. Ms. Stevens's parents are residing in the Yellow Brick Road home. The suggestion that she would be responsible for the property taxes and insurance, my client tells you, and it's undisputed, that she paid the full property taxes for 2024 for both the Yellow Brick Road home and the Tarumi home from the community proceeds shortly before the party separation. So there is no tax debt for those homes that are owed for 2024. She paid almost $8,000 from what was in the community savings. Insurance, homeowners insurance, is paid annually. That's already been paid. So she doesn't have those expenses. And when you look at her financial declaration, you'll note that she doesn't identify that she has any expenses relative to homeowners insurance or taxes. In regards to the Wool Road home, there is a mortgage. The mortgage is $2,172.37 each month, and that includes taxes and insurance because that's paid through the mortgage. It is our position, first off, when you go back and look at Ms. Stevens's petition, she identifies at paragraph 7 that the Wool Road home should be awarded to my client. And that's because he has significant, if not complete, separate assets within that residence. There's been no evidence at this point as far as the suggestion that there's been community improvements to the residence. It was brand new in 2008. And so our position is that the Wool Road home should be awarded to my client. This suggestion about Carter being a nexus for not allowing my client to remain in the family home, Ms. Stevens and Mr. Stevens already determined that it was inappropriate for Carter to be in the residence because of his behavior. It's undisputed that Carter has been using marijuana since the age of 13. It's undisputed that Carter reacts volatilely, and that in March he smashed out Ms. Stevens's computer system within her vehicle. That's all undisputed. His behavior has been horrible towards my client and horrible, quite frankly, towards his mother. This is a teen who is out of control. There's an attempt to suggest that his behavior is related to his health diagnosis, but there is not one shred of medical evidence to support that claim. And these parties both decided that it was not safe for Carter to be in the home, and he's been residing with the maternal grandparents since March of this year. The suggestion that he hasn't already moved, I think, is a foregone conclusion. He's been there 100% of the time, so much so that Ms. Stevens has even decided to pledge the community rent by not having her parents pay the rent. That's not my client's obligation. That's her sole decision, and my client should have been included in that decision. We provided to you the tax returns that shows, excuse me, that she has not been collecting full rents for 2023, that it's acknowledged that she's not collected the full rents for 2024. That's not in the community's best interest. So she's behaving in a manner that is not in the community's best interest. My client tells you in his reply declaration that she has paid out not only the full taxes, but she also paid out significant credit card debt for herself of $7,700, which we believe includes her retainer to Ms. Powers, but she hasn't been forthcoming with those records. She's paid out substantial uninsured healthcare expenses for Carter, again, without my client's input or directive. And when you look at her financial declaration, even her own financial declaration indicates that her net income is $1,000 greater than her need. The suggestion that my client should continue to pay the home mortgage should only be if he's residing in his property. He should be allowed to remain in the property. Ms. Stevens can sleep on the floor in the guest bedroom or sleep on the sofa until she gives the renters at Tarumi Lane notice that they need to move, and then she can move into the Tarumi home because she's asking to be awarded both the Yellow Brick Road Lexington home as well as the Tarumi Longview home. So those are available to her. There's no mortgages on either of those. The taxes and the insurance are paid, and she already has sufficient income to provide for her and her child's needs. I would also note that both of these parties, the community savings account was split, and they both have about $30,000 available to them. So the suggestion that she's going to have to move Carter a second time, well, the second time is going to be in a residence that he's well aware of because Ms. Stevens has owned that home. It was completely remodeled, except for I think maybe the kitchen when these folks got together. So that is a home that's clearly available to her. We're asking that the court order her to move from the residence no later than June 2nd. That would be this Sunday by 12 noon. We think that that's appropriate. We've provided in the proposed order our request as far as the vehicles that she should take, that she should remove her personal property and equitable share of the community property that's agreed upon between the parties. If there's a disagreement, those should remain until either counsel and I can work that out or we bring it back to the court. Third parties should be present. I mean, obviously, as we're getting close to these hearings, things have ramped up, and we are asking that third parties be present when these moves take place. It is our position that there should be no firearms present at the residence or concealed by any party during the exchanges. In regards to the suggestion about setting the toys, as it were, aside, our position is that those should be allocated under the temporary orders. The parties are already paying the insurances. Each has on their financial declarations about $250 per month, which covers the vehicles that are in their possession that they're requesting. My client uses the travel trailer. He uses the side-by-side. He uses the jet sled. He uses all of these on a regular basis. There's absolutely no supporting evidence that either of these folks are going to be put in financial constraints by maintaining the insurances and allowing for the continued enjoyment of these respective vehicles. Ms. Stevens has not requested to have or use the vehicles that my client has asked to be able to continue to use. And we're asking that the court allow him to continue the enjoyment of those assets. In regards to bear with me. The other thing that I would point out as it relates to this transition, obviously Carter's going to be done with school here in the next, 2 weeks or 10 days. And so there's going to be summer. That's going to be a good transition time to be able to get him acclimated into a new home. Quite frankly, we think it's a bit of a red herring given the fact that he's 17 years old and has already moved from the residence. We are agreed to maintaining the restraints as far as not disposing of assets, not disposing or not pledging the community for purposes of any future debts. Each should be responsible for their own future debts. We are agreed to no spousal maintenance or attorney's fees. The suggestion that my client should continue to pay the home mortgage while she's residing there. He does not have the ability to do that because at this point he doesn't have another residence. She's clearly not offering up the two-roomy house for him, even though that's in her name and clearly available to her. So there's 3 houses here. She and Carter can have one. My client needs to remain in the Wool Road home and her parents can continue in the other. We are asking that, actually in regards to the cell phone, it sounds like there's no disagreement to segregating the cell phones. I'm not aware of there being any cost. I understood that the cell phones were already paid off, but Ms. Stevens needs to sign to release both my client and his son's cell phone numbers since they've had those for extended period of times. My client denies that there was any cash in the safe or that he's removed any cash from the safe. My client has not removed her diamond earrings. In the past, she actually lost a diamond bracelet. So he's done nothing with those. We do believe that the security system should be resumed. That has apparently Ms. Stevens has removed the controller for that. The security system needs to be maintained to ensure the security of the property. Again, that's in the community's best interest. On the other hand, I guess I would provide that this is notice that there are not to be any unauthorized videos of my client as has recently taken place. If there are future videos that do not comply with the statute, we will be providing a notice to the Sheriff's Department. In regards to, let's see, we are agreed as far as the debt allocation, again, assuming that the court orders Ms. Stevens to move from the residence. I think that's it. And we have provided a proposed temporary order to the court.
Ms. Powers?
Thank you, Your Honor. Just briefly in reply, I would point out for the court, my client did include the cost for insurance and taxes on the rental homes. It's under paragraph 10, page 5 of her financial declaration. I'd also indicate that My client in her reply declaration and her mother in the reply declaration explained that they all anticipated Carter's removal from the home being very temporary. My client thought that we needed a little cool down period and he'd be back at home. There wasn't a full agreement that he was permanently out of the home. Carter's still a high school student. He's a child. He's had some difficulties. He has significant health issues, and his mom is not giving up on him and wants to be the present parent in his life. Just because teenagers get difficult sometimes does not mean you throw your hands up and stop parenting them. And that is not her intent here. So Carter has been out of the home since the end of March, but my client's intent was that that would be a very minimal temporary change. Mr. Stevens indicates that my client may be able to evict the tenant at their other rental. She might be able to do that, but that takes away $1,700 a month in community rent to both parties. And the parties have agreed that my client will be in charge of managing those rental funds. So that's less income available to her, which is more reason that Mr. Stevens can be responsible for the mortgage at their home. The taxes for the family home that they're living in come out of the mortgage. There is a mortgage on that property. In terms of the cell phones, again, we'd ask that when money's owed on either of the phones that be paid off before this all be released. And then lastly, in terms of videos, we'd ask that neither party have unauthorized videos of the other party, that go both ways. Thank you. Oh, and one last thing, there are a lot of allegations that about my client, her finances at the beginning of the relationship, money contributed to the homes, and whether what has happened with rental money. All of that needs to be fleshed out in discovery and at trial, and really should be handled later in this process. And my client agrees that Mr. Stevens might end up with the family home at the end, but we're asking that in the meantime that my client and Carter be allowed to reside there at this time, and regardless of what the ultimate decision is down the road. Thank you.
All right, I did review the files and record, everything that was submitted, and considering the argument here today. I may touch on some things that you've agreed about, and if you have, just let me know. I didn't keep track of everything that you had agreed upon. There is no doubt this is difficult. On one hand, you want to say, well, this is simple. We have a parent with a child, and there may be some standards that go along with that. But this is a different scenario. It's not a short, or it is what I would call a short-term marriage. And so looking at this a little bit different in looking at the idea of the wife wants to stay there and move the son back to the what's been called the family home. And then what's going to happen, because it's clear from everything that I've heard that appears to be his separate property. Maybe there's more being contested about that. I don't know. And then what? Then the mother and then I'll just call it child have to move again. So where are they going to move? So there are a lot of different factors here that aren't going to typically exist. The court does have concerns in regard to the child's behavior, whatever may be the cause, it doesn't matter. But there are concerns, and I understand when the husband is not wanting to have that child back in the family home, and that the child has been out of the family home since March. So those are all factors the court has been weighing here. And do you stop things from changing now, or do you go ahead and do things that are going to get people moving forward as to what they are going to do? It is difficult. Each party wants to remain in the family home. However, the wife is also wanting to have the husband pay the mortgage and insurance for her to live there with her son. And as I said, then you have the son already living with the wife's parents. There is no good answer, bottom line, except if the husband can afford to pay the mortgage and the wife says he wants to keep it. So at this point, then he will do so as to remaining there, as well as pay the insurance. Whether the wife moves into the house where her parents are at, or evict the other renters from the other home, that is up to her, or whether she goes and finds a totally different home. No matter what, it all comes down to about the same amount of money that you're talking about. So at this point, whether she chooses to move in where the parents are, evict the people out of that other home, that's up to her. But the wife will be required to leave. Now, I am giving her more time than I typically would, just because if it's a matter of having to get somebody else moved out of the home, whether she stays at the family home during this time or moves somewhere else, that's her choice. But the child at this point is taken care of living with the grandparents. So the court is not looking at this in the same way. So I am giving her until June 28 to figure out what is going to happen as where she and the child go. Again, whether that's to where the parents are or the other, that's completely up to her. Though
Your Honor, may I ask a question?
Go ahead.
Can we provide a provision that Carter is not to be brought to the home?
That's fine.
Okay.
The wife is to leave the house, as I said, by that date at 8 p.m. The wife will turn over keys, remotes, and any fobs for the home upon moving. And the wife, again, depending on what happens here, shall receive 100% of rental income for the 2 rental properties and be responsible for the insurance for the 2 properties. The petitioner shall have the use of the 2001 Crown Line boat and 2001 tandem trailer, 2016 Buick Enclave, 2016 Subaru Impreza, and the family dog. Now, the question is, and I wasn't really sure, and is that as far as whether there's a place to take those things. That's what I didn't really understand is, Ms. Powers?
At this point, my client does not have anywhere to take those items.
Okay.
I understood that Carter was already driving the Subaru. She drives the Buick. As it relates to, as it relates to the dog and the boat and trailer, I'm assuming my client wouldn't have any objection to those remaining at the home. Is that acceptable, Russ?
Yeah, that's fine. Yes.
Okay. So depending on what the wife can do to either move those or leaving them is fine. So there aren't storage costs or anything else like that need to occur.
And I just ask if my client leaves them that they sit and not be used.
That's fine.
I'm assuming you're referring to the boat and the trailer.
Yes, the things that have just been allocated to her to use.
Okay. Well, I mean, obviously the dog. I'm
assuming the dog will be taken care of if he stays at the house.
Okay.
So is the dog going to stay at my home?
We'll figure that out.
No, I think my client can find a place for the dog. It's the boat and the trailer that's the big concern.
Okay.
And I'd ask that they stay stored the way they've been stored.
Okay.
Yeah, we had discussed 2 months ago to sell that boat.
Stop.
Okay.
All right. And then I think you agree to this. The petitioner shall have sole use and access to the Fiber Federal Credit Union. Respondent shall remove his name from the account. Petitioner can remove her personal property and community personal property as agreed upon by the parties. Each party can have a person present to witness the other terms, Ms. McLean, that you talked about, the gun, and those can be included as well. The respondent shall possess and use the 2019 Genesis Cortex toy hauler, the 2017 Jeep Grand Cherokee Spirit, 1964 Chevrolet Malibu Super Sport, 1996 Fish Something Explorer jet sled, and 1996 tandem trailer, the 2019 Can-Am Maverick side-by-side, the cargo trailer, Yamaha YFZ 450, the 2004 Mazda 3, 2017 Ford F350. The respondent shall use the Red Canoe Credit Union and
sub-accounts in the HSA.
Right. And then each shall be responsible for their own auto insurance effective June 1, 2024. There was something about an umbrella policy in there. I didn't know what that was about. I don't know if it got left over from something else or what. I just saw umbrella policy.
I know that my client had requested that Mr. Stevens pay for the umbrella policy.
Okay.
I'm not sure what the umbrella covers.
It's a $2 million blanket policy that umbrellas over all of our insurance.
And
do you
know
what the monthly is?
I don't. I would have to find that out.
Ms. Powers?
Unless Mrs.
Okay,
Stevens.
all right. Ms. Powers?
Ms. Stevens indicates that it's primarily covering all the toys and that sort of thing.
Do we know what the monthly is, or is it paid annually?
It's $550 semi-annually.
All right, so the husband will pay that. He's got most of the toys. I think you agreed both are not to move, take, hide, damage, borrow against, sell, or try to sell, etc. That language is mutual. The respondent shall pay the mortgage, utilities, and insurance and taxes for the Wool Road house.
So there's no 50% responsibility while she continues to reside in the residence?
I have these houses confused a bit. Is the Wool Road not the family house?
That is the family home.
Then he's to take care of it.
Okay.
And the respondent shall transfer the Navy Federal Credit Union mortgage auto payment from the Fiber Federal Credit Union account effective immediately. I want that taken care of right away. The parties shall separate their cell phone plans by June 7 and each be responsible for their own plan. And I think you had the other debts taken care of, correct? Agreed upon?
I believe so. I know that Mr. Stevens had listed a credit card for Miss Stevens that she does not have. So she does not have the Chase card, but she'll pay the Citibank card, which is her credit card.
Okay.
So I guess I would just suggest that we reserve on that because I understood that she had a Chase card.
Okay. Reserve on it. You may have to run a credit check and see what's there. She may have it and just not used it. Neither party is to change to medical, health, life, property, etc. That language should be included. And the respondent husband shall pay $3,000 in attorney's fees to the petitioner's attorney. Are you agreed on none, didn't you?
Yeah, they agreed on none because she
We
had
had agreed.
$30,000.
Yeah, we had agreed that it could be handled at finalization.
Okay, disregard that then. All right, is there anything I missed?
I don't think so.
Okay.
Presentation.
So June 18 would be the next.
And actually, now that you say if there was anything that was missed, the video recording.
Are you talking about nobody? Yeah, that's fine to include that.
All right.
Make it mutual. And I would ask that none of this be on Facebook or any other source of social media. You do have a child involved and it's just not appropriate. So let's keep it out of the social media realm.
Can I have one more clarification with the cameras? It's my understanding that a camera has been installed inside. Can the parties agree to just have that turned off until my client is out of the home?
I'm not aware of a camera inside. I know that there's security cameras outside.
Okay, any cameras that are inside should just be turned off.
Otherwise, the security system should be running.
Yes.
All right. Okay.
All right.
Thank you.
All right. Thank you. That concludes this docket.